When did a wacky or specific law win a court case? I got a pro bono client's removal by USCIS cancelled. He had a low-level substance possession conviction from the early 1980s. During that brief period, the active ingredient of Imodium was illegal under state law but not federal law. So I successfully argued that they couldn't prove it wasn't a conviction for possession of a substance that was federally legal at the time, and as such was not subject to removal. The argument worked, and my guy went back to his business and his family. I had a case where a guy was charged for running a red light. The thing is, he'd been sitting at the lights for 5 minutes and it hadn't changed. The wording of the specific section under which he was charged related to stop signs and traffic lights and referred to them as traffic regulation devices. I successfully argued that as the traffic light wasn't changing, it wasn't regulating traffic, and he got off. I couldn't believe it when the judge ruled in my favor. Neither could the police prosecutor. I did some research for this case when I was a law student, Jolie vs. Palacier, 1999. Some background, this was at a time when the Ontario Court of Appeal had held that, if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That's not the case today. It was discovered that this position basically ruined summary judgment as a useful process. But it was the case at the time. In such a motion, all facts alleged by the plaintiff would be assumed to be true. What happened was this. A man sued, among others, the College of Dental Surgeons for persecuting him and interfering in his ability to live as a generic Martian. The plaintiff claimed he had been cloned from space debris NASA found in the 1960s. He claimed he had a genetic test to prove this, but it had been falsified by the CIA as part of the conspiracy against him. Well, naturally, this claim raises the concern that the plaintiff was bonkers, but there was no evidence, aside from his bizarre claims, of that being so. In court, the case was decided on 2 alternate grounds. First, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on a more entertaining basis of standing. Justice Epstein held that only a person could commence an action in Ontario. The rules of civil procedure define a person to be either a human being or a corporation. The plaintiff's whole case was based on him being a Martian. If he was not a Martian, the case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. Well, Ontarians, you can rest easy knowing that one particular section of the extraterrestrial community can no longer take you to court for emotional copyright and, most importantly, property damages. You know what that means. Man the artillery in Ontario and let's get those Martians before they sue us. 47 USC 227B. Restrictions on use of automated telephone equipment. Law student working at a law firm here. We have a fax machine that gets tons of spam faxes. Our chief partner has a vendetta against spam, and he uses it to give us practice in researching and writing petitions. So we catalog each fax, send replies to take us off the list, document everything and wait for them to fax us again. Then we follow up with an FCC complaint and a demand letter. A couple of times this has ended up with the person getting mad and sending us retaliatory faxes, black sheets of paper. If they stop sending, we don't do anything. But we've gone to small claims a couple of times and gotten $500 per page a few times. We also got someone trying to sell substances through fax, but we just turned that over to the police. I had a client with a serious medical problem that cost her job, and she was preparing to file bankruptcy on the medical bills and credit card debts. Thing was, she had like 15 grand socked away and didn't tell me. It was all that was left of her life savings. Before we filed her case, she gave it to her mum for safekeeping. What she didn't know is that she could have kept the money through the bankruptcy, but giving it away beforehand is a no-no. I had to tell the court when I found out, and when this happens, the court gets the right to sue the mum for the 15 grand. The thing is, the mum's debt to her daughter's bankruptcy court? Also dischargeable in bankruptcy. So the mum filed bankruptcy too, and they got to keep the money after all. The Canadian Interest Act specifies that all interest must be specified in a per annum percentage. If it's not, it's struck down to 5% simple interest per year. The number of lenders and creditors who try to pull off a 4% monthly compound interest but aren't familiar with that provision of federal law? Let me explain. Shady outfit offers to sell you a used car with an interest rate of 3% per month. Neglects to mention that it's 36% per year. Debtor makes payments that they think should equal the correct value, only to learn that most of their money went toward interest. Demand letters and claims tended to go away quickly upon faxing over that page of the statute. I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win a case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside the Natural History Museum and shattered her arm and wrist. The law is that the property owner is responsible for the sidewalk directly outside their property, the theory being that even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very, very stupid law that they would be exempted from the rule that they can't be sued for sidewalk injuries unless you can show that they were on notice of a hazard, meaning that you would have to show that you informed the Secretary of State or Governor or Mayor of the exact specific crack in the sidewalk before the injury occurred, and that you had to do so in writing with ample time for the city to remedy it. 180 days in advance, if I recall correctly. Under normal circumstances, this is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a non-profit group called Big Apple Maps, which would go around the city with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps while serving copies on the government, with the express purpose of combating sovereign immunity defenses in slip-and-fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed cement over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client had slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map. Immediate settlement. I had a friend trip over a huge crack in the sidewalk. The city tried saying they didn't know. I'd submitted pictures and a complaint about the crack almost a year prior. He was very thankful I did it, as it basically won his case. There was a case here in Hawaii that got thrown out. Someone got pulled over because the police saw that she had way too many passengers in the car. Then they noticed she was drunk. Open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle. So the issue was that all the extra passengers weren't wearing seatbelts. Well, this failed also because the law only says that every available seatbelt needs to be in use. If you have 6 passengers and only 5 seatbelts, there's nothing at all illegal about the 6th being unrestrained. So, since there was no probable cause to pull her over in the first place, even though she was indefensibly drunk, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they can just party back there, while anyone in the cab unbuckled would get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs. I mean, that last image is both hilarious and ever so slightly concerning. My GTA instincts are just envisioning the inevitable crash and subsequent catapulted people being shot out like a basket of rocks from a mangonel. I think something's wrong with me. I had a roommate who got picked up for public intoxication one St. Patrick's Day. He was in jail for a couple of days, which seemed odd for a PI. Turned out he had a warrant from another city for escaping jail. The year before, he got picked up for public intoxication on St. Patrick's Day? He had a hazy memory of being shuffled down a hallway with a bunch of other drunkards at the jail before walking through a door and suddenly being alone outside. From there, he just walked home. The police never came looking for him, so he wasn't sure it had happened. Anyway, it turns out they never even properly booked him, so while there was a warrant for him escaping jail, there was no record of him ever being arrested. Case dismissed. This is how a lot of DUI cases are argued and won in the US, that the initial pullover wasn't justified or that there wasn't a legitimate reason to investigate a DUI after the pullover, or insufficient reason for arrest. Even if you blow over on the breathalyzer, they have to have enough reason to have you blow in the first place. I have one where we won, but it didn't go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40 to 60 hours a week preparing slop for the hogs from expired restaurant food and cleaning the hog barns. He reeked every time I met him, even after showering. He said it was miserable. Well, he found out that some Muslim inmates who couldn't work with pigs were offered to be able to work at the police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction, but then the prison changed their policies in response. Inmates who couldn't work around pigs or didn't want to would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. A guy I know got drunk and decided to ride his horse through town. This was a small town in North Carolina. Well, he'd stop at each intersection and fire his pistol in the air like some Wild West cowboy. Anyway, the guy was charged with a DUI and discharging a firearm within city limits, which was a felony. So, as one would soon find, it's not just mandatory, but a law you must fire your firearm into the air at an intersection when coming through town on your horse. An old blue law that never got erased. He still got the DUI and his horse got impounded, but the dumbfounded judge dropped the other charges. You can submit your own stories to be featured here on the channel. The story submission link is in the description below. And if you want to listen to some vibey music in the background, check out Easy Mode, also linked below, and subscribe. Over 10 years ago, I'd been at fault for rear-ending someone else. I had no insurance and my license had expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of a fix-it ticket about my suspended license. I sorted that out in the days after, and nothing came of the ticket. The cop had mentioned that he had to write the insurance ticket, but to take it into court and get it lowered. I was desperate to try and get my $800 insurance ticket lowered because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped, and said, "I would like to use Mr. South Seattle's case as an example to the gallery." I almost died. He went on, "This is a court of law, but it's also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. South Seattle accountable to this." My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure that the cop deliberately didn't write the date on the ticket. Thanks, officer. I had a very similar thing happen. I rear-ended someone, but it turned out the person I hit had a warrant for their arrest. While other cops were taking care of that, another came over to me and gave me a ticket. While he did that, he flipped it over and showed me the instructions to fight it in court. Well, I followed those instructions, and when I got to court, the officer had a family emergency and wasn't able to go, which threw out the case and also my ticket. Thank you to whoever that was. Had a case where the defendant, my opponent, filed an appeal from an administrative agency to the local circuit court. The requirement for filing the appeal was very strict, and the filing must include an appeal bond, executed by the individual defendant or a corporate officer. When my opponent's assistant electronically filed the appeal, she attached a PDF of the bond, without the corporate signature. There's no question in my mind that they had the bond with the requisite signature, and simply attached the wrong version of the document to the filing. I wish I could say there was a huge court fight over this, and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent and told him I was holding the I win button, and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client, but I doubt it. In 2016, prison inmate John Modi was charged with escaping from the prison in which he was incarcerated, which is a crime in Ohio. The prosecution, however, failed to establish that the Hocking Correctional Facility, and therefore the crime, was located within the court's jurisdiction of Hocking County, as all witnesses potentially able to offer testimony on the prison's location had gone home for the day. And, incredibly, no one remaining could provide references allowing the court to take judicial notice of the prison's location. The charges against Modi were dismissed and he was allowed to return to prison to serve his sentence, but at least without additional charges concerning his alleged escape. Okay, for a second the narrator thought that Modi was going to just be let off scot-free, which would have been a massive oversight if he was a repeat murderer or something. However, that notion isn't impossible in some jurisdictions it seems, as the following story indicates. I had a family friend, old guy, passed away now, who said that he was able to escape from prison, and because he escaped, was let go. Because no one was supposed to be able to escape from that prison or something like that, he sometimes told stories. But the few things he told me about his crimes, major theft, I didn't believe. But I later saw the court papers and they were true. He was a jailhouse lawyer and had a whole bookshelf of legal books. I don't recall which prison it was, although I know he was in Arkansas for at least part of his stay. Not a lawyer, but I did enough law research to get myself out of a parking ticket one time. When I was in college, I was in the marching band. We had a storage room in the basement of one of the dorms. I was going to get something out of the storage room and parked in the loading dock behind the dorm. There was just enough room next to a dumpster to fit my car. I didn't want to spend $5 on a loading zone pass from parking services because I was a broke college student, so I just parked. I was only going to be 2 minutes anyway. I finished picking up what I need to. Sure enough, I came back out to my car to a parking ticket. Except it wasn't the $25 ticket for a parking in the loading zone, it was $75 tickets for parking in a fire lane. What the frick? There was a single sign at the very front of the side road leading up to the loading zone, but no curb paint, no indication of where the fire lane started and where it stopped. I called parking enforcement telling them this and they wouldn't budge. Fine. I took pictures of the loading dock and I submitted an information request to obtain the evidence pictures. I got the pictures and started researching fire lane requirements in the state. What I found clearly indicated that curb stripes were mandatory. I called parking enforcement and told them what I found and they still wouldn't budge. Frustratingly, I looked at the law again. The part they cited for me said that nothing could obstruct a fire lane at any time. I looked back at the evidence photos and saw the dumpster next to my car. If this was a fire lane, then the dumpster was blocking the fire lane too. The same state law they cited me with said that non-vehicle obstruction of a fire lane was subject to a fine of $1,500 per day. I found satellite imagery from 4 years prior showing that the dumpster had been there for at least 4 years. So I argued to university parking enforcement that if this was a fire lane, then the university had been obstructing it for the last 4 years and would owe the state $2.2 million in fines if I reported it. The parking ticket disappeared immediately when I sent the appeals committee their own evidence photos, satellite imagery, and the same state law they cited me with. I drove by a week later and the dumpster was gone, the curb was painted, and 2 brand new fire lane signs were up. In short, got a parking ticket for parking in a fire lane at my university. Successfully argued the university owed $2.2 million in fines to the state if it was really a fire lane, and the $75 parking ticket was dropped. The first and only time I ever used the subway station's emergency door to get to the train, the ticket gate wasn't working, it was 3 a.m., I was a drunk college kid trying to catch the last train home, and basically I got caught by 2 subway officers and given a ticket with a huge attempted fare avoidance fine. I showed up to the hearing in desperation and they ended up having to drop the fine as they were reviewing the case with me because one cop had recorded that I entered through the right-hand emergency door and the other wrote that I entered through the left-hand emergency door. Never been so grateful in my life. I once won a case that forbade the possession or transport of human urine in order to adulterate a urine screen. I had a client who was caught with a little container of alleged urine that he may or may not have been able to use to mess up a drug screen. Since he hadn't messed with a drug screen or actually tried to mess with one yet, he couldn't be charged with that. So he was charged with trying to transport human urine with the intent to adulterate a urine screen. It wasn't human urine. It was fake lab-made urine from a website, meaning that I got to argue, 1, the prosecution hadn't proven it was human urine, they hadn't tested it, and 2, they deprived us of the opportunity to test it because the officer poured it out before giving the container back to the client. And 3, my client could literally testify that it wasn't human urine. He's still known around the office as Human Urine Guy. We have a lot of nicknames like that around here. Human Urine Guy, Drywall Guy, Donkey Kick Guy, Fire Truck Guy, Backpack Girl, Cornhole Board Guy. As a bonus, the prosecutor got offended because I made a motion to suppress the search of my client based on violation of the 4th Amendment. Prosecutor thought we'd agreed that the search was good. The search was good based on the facts in the police report. Not my fault that the police officer testified like an idiot once he got on the stand. My brother is a lawyer. He got a DUI charge dropped for a client. Guy gets pulled over, the cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car, he asks the officer if it's okay for him to reposition the vehicle to move it further away from the road, because he feels uncomfortable with it being that close. The cop obliges. Apparently, the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. This happened with a guy I knew on his boat. He has a huge 65-foot Viking, and the cops couldn't dock it, so they asked him to. His lawyer shows up and says, "The cops made my client dock his own boat after they decided to take him in for DUI. Sober Water Patrol couldn't dock the boat, but an impaired person can?" The case was dismissed. I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside table, walked into his living room, and confronted the figure in the dark. The person didn't identify himself but moved towards my client, who fired a single shot that went through the person's shoulder. Turned out it was my client's stepson who'd snuck out, been drinking underage, and stumbled home. The problem with the situation was that my client was a convicted felon, several times over. That meant that while the shooting itself was legally defensible, his possession of the firearm was not. We looked into the history of the gun itself, as our client had indicated it had belonged to his grandfather, who'd served in the US Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the first batch of firearms distributed from Colt to the US Army at the Augusta Armory. Florida Statute 7090.001 creates an exemption of firearm-related laws, including the prohibition for felons to possess a firearm if the firearm in question was an antique, meaning it was manufactured prior to 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potential mandatory prison sentence. When you subscribe, make sure to hit the bell to turn on notifications. Put the playlist on in the background to finish listening to all the stories, or if you want some vibey music to put on in the background, check out Easy Mode. If you like Am I the Genius, give Am I the Jerk a shot. Everything linked in the description.